Wait, please, my lord.
Yes.
Lordship, in item 2, I have
Yes.
filed an affidavit this morning showing the latest progress report of the road under construction. I am for the authority engineer, the respondent number 10, Lordship. Therefore, if the
You are
affidavit
for the respondent number?
10, Lordship,
Respondent number
if
10.
the affidavit can kindly be called, Lordship. Because I
Today, right now?
yes, yes,
Okay.
I have already filed this morning
Okay.
because I believe the affidavit is essential.
Yes.
Could be of-
Okay. Okay.
May I please, your lordships?
Yes.
I'm appearing on behalf of the National Investigation Agency, item number 3, lordships.
Yes.
I pray that the matter comes up on 13th of December, the next month.
Why?
The respondents have filed their affidavit in opposition and we have received yesterday only.
Hmm.
So lordship, if the matter may fix on 13 lordships.
Your good name?
Apila Sanctam
Miss Apila Sanctum, Learned Counsel, appearing on behalf
on
of
behalf of NIA.
NIA, submits that the matter may be listed on 13th of December as she has received the affidavit in opposition filed by the respondent yesterday only.
Lordship.
Yesterday only. Pair of Ms. So-and-so is accordingly allowed. List the matter,
My lord.
list the matter on 13th of December.
My lord, the name of R.L. Izong, Esther Aye, and Lasika may be reflected in the cost list.
Acha. As paid for by Mr.
Pakinucha po, my lord.
The name of
R.L. Izong,
R.L. Ijung and
Esther Aye,
okay. Shall be reflected in
Lasika.
the cause list. Okay. Yes.
Lordships, I beg to mention for item number 7, PIL 23
Yes.
of 2020, lordship.
Yes.
I'm appearing for respondent number 4.
Yes.
I may be allowed to file my affidavit in opposition, so I may be allowed 3 weeks time, lordships.
Who is for the petitioner?
Lordship, I'm for the petitioner.
Any objection?
No, your lordship.
Okay. Miss Apila Sanctum, Learned Counsel for the respondent number 4, with consent from the other side, press for listening the matter after 3 weeks,
Lordship,
so as to enable her to file affidavit in opposition.
position.
PR is accordingly allowed.
Lordship, applies lordships.
Lordships,
Yes.
I may be allowed to mention item 17 of the hearing. Yes.
17.
Yes.
Yes.
This matter may come up next week.
Next week.
Yes.
Yes. Your good name?
L. Iralu for the appellants.
N. Iralu. Mr. N. Iralu, Learned Counsel for the appellant. You inform the other side?
Yes.
With
For
consent from
respondent
the,
3 and 4.
with consent from the other side, press for listing the matter in the next week. PR is accordingly allowed.
I'm acknowledged.
Please, your lordships.
Yes.
Lordship, I may be allowed to make mention for single bench matter, on urgent matter
When?
tomorrow, lordship, for taking together of WPC number 2, 3, 4, and 2.
Okay. Okay. Yes.
Mention item number 14.
Yes.
Lordship, I'm yet to receive the instruction in this case. I have already filed my affidavit. but
Affidavit.
I've already filed, but I was instructed to file an additional affidavit.
Hmm.
So I may be given some time.
Mr. So-and-so, Learned CGC.
Yes.
CGC prior with consent from the other side, press for listing the matter after
After the vacation, lordship.
after the vacation.
Vacation, lordship.
After the vacation. Okay. PR is accordingly allowed.
Please, Lordship.
Yes.
Lordship, I beg to mention item number 1, Your Lordship, in motion, Lordship.
Yes.
Lordship, I pray that this matter may come up next week, Lordship, since we are yet to file our IA, Lordship.
Item number 1.
Yes, Lordship.
Your good name?
Metovero, Lordship, on behalf of Dipender Roy,
Mr. So-and-so, Learned Counsel on behalf of,
the petitioner, Lordship.
appearing on behalf of
Dipender Roy.
Dipender Kumar Roy. Counsel for the appellant. Press for listing the matter
Next week, Lordship.
next week. PR allowed. Yes.
Obliged, ma'am.
May I please, the lordship? Lordship, I beg to mention item number 16, lordship. On behalf of Yang Gami, lordship. Item number 16. Lordship, I pray that this matter come next week.
Lordship, let this matter be listed on 6th. Next
Yeah, I have listened.
Yeah, smart guy. Thank you. No, in Kai personally, we see the Hornbill Festival. You tell the guys this buggers कि नितेंद्र रॉय को भेजो एडमिशन हियरिंग करवा देंगे 5 भी हो जाएगा उस दिन प्लान बनेंगे सेकंड हाफ में एडमिशन हियरिंग कर देंगे हाँ ये विल मेक एन एप्लीकेशन टू द ओपोनेंट एडवोकेट since advocate Nitendra Roy is coming from far away so उस दिन हम लोग एडमिट अगर हो जाता है you can keep the this thing in the second half and at the same time you make the admission hearing next week okay.
Yes,
Our lordship, I pray that this matter come next week, lordship.
next week.
Lordship.
Your good name?
Lordship, let this matter be listed. In that case, let this matter be listed on 6th. Lordship.
Yes, your good name?
Vijimomi.
Mr. V. Jimomi,
On
learned
behalf of-
counsel appearing on behalf of
Kiangami, lordship.
K.
for the
Ngami,
said-
learned PP.
Lordship.
PP with concern from the other side, based for listing the matter on 6th of December.
Yes, Lordship.
Okay, fair load.
Much obliged.
Next, my lordships, I beg to mention item 15.
Yes,
15 lordship, the matter to come up next week, lordship. My seniors in difficulties today,
you are for the petitioner,
lordship.
Mr. Fosiko Patel, learned counsel for the appellant with concern from the other side, based for listing the matter in the next week. Fair load.
Next week, lordship. Obliged, my lord.
Yes.
May it please your lordships. Lordship, I beg to mention item 11. Lordship, here we have received affidavit in the position filed by the state this morning only. So if this lordship can fix this matter on Wednesday, 6th of December, lordship.
Your good name?
Mika Aye.
Miss Mika Ace Aye,
Lordship.
learned counsel for the petitioner with concern from the other side, press for listing the matter on 6th of December.
Lordship.
6th of December. As the state respondent has filed affidavit in opposition. When it was filed?
This morning.
Just this morning only.
This
we have
morning
served-
only. This morning. Where is accordingly allowed, raised it to list the matter on 6th of December.
Much obliged.
Lordship, Lordship, I beg to mention item number 9.
Yes,
Yes, Lordship, I pray this matter may come up after the vacation.
okay. Miss so-and-so, learned senior government advocate. You are for the petitioner?
Petitioner, yes.
Any
sir, lordship.
objection?
No objection, my lord.
With consent from the other side, price for listing the matter after the vacation. Where is accordingly allowed. Yes.
Lordship.
For admission, item number 2.
So as per last order, respondent number 8 and on 9 and 10 have to file affidavits
Lordship, I have filed the affidavit this morning. The respondent number
on
10
behalf of both the respondent 9 and 10.
No, Lordship. For respondent number 9, my learned friend Joshua, who is representing, he has also filed his affidavit this morning. Lordship. And I am for the respondent number 10. I have also filed my affidavit this morning. The progress indicated in my affidavit, Lordship. There is an improvement of about 5% from the last 10. Lordship. So at present, the physical progress is as on 27th of November is 49.27 and the financial progress is 44.89. Here, Lordship,
Yes,
there is a slight difference in the figures indicated in my affidavit and in the affidavit of the It's only number 9, that is the contractual lordship. It is because we are including only those portions which are fully completed. Whereas my learned friend, in his affidavit, they are including those work which are actively under progress as well.
Mm.
Which is why there is a slight difference. His, it will reflect about 51%, mine 49.27.
49 point.
27 lordship.
And
Right.
Mr. Sekis,
Yes, for the
progress?
respondent number 9, Lordship.
Yes, your progress is?
51.54, Lordship. And here, my lords may kindly appreciate this fact also.
Mm.
The 2.1 kilometers out of this total stretch percentage, Lordship. The
Yes.
2.1 kilometer, it is executed by the national highways, the state.
Mm.
The Lordship, that will also be minused. And if that is minused,
Mm.
my lords will kindly appreciate that the actual overall percentage of progress is actually more than 60%, Lordship.
Mm.
But we are including the 2.1 kilometer also because that is yet to be removed from our work specification, your lordships. Further, my lords will kindly appreciate that may I take your lordships to my affidavit, the page number 5, respondent number 9's affidavit. If my lords have received a copy.
Yes, yes.
May I take your lordships to annexure A, page number 5.
Yes, page number?
5, annexure A.
Yes.
Serial number 14, my lords. Surfacial protection and erosion control.
Yes.
Your lordships, due to change of scope, the road widening was not done.
Mm.
So, my lords, since no road widening was done, there is no provision for surfacial protection and erosion control also.
Mm.
And my lords, if this is also done away with, then my lords will kindly appreciate that the actual progress will be nearly 70%, lordship. And
Acha.
the top part of the document which I am relying upon, my lords,
Mm.
your lordships, the subgrade serial number 1, EW up to subgrade top.
Yes.
We have completed up to 92%. GSB, we have completed up to 85%. WMM, 54%. DBM, 43%. And the BC, that is the final layer. Your lordships, due to favorable weather condition these days, this BC, it will not take time, lordship, because the initial 3 stages, that is the GSB, WMM, DBM, once this portion settles, BC doesn't take time, lordship, the carpeting part.
Mm.
So, your lordships, the progress of work during this favorable season, lordship, we will be able to complete the work, and the authorities are also aware that we are given up to March 2024.
March 2024.
Yes, lordship, but in most likelihood, we will try to finish the work before that, lordship. It's a limited working season as far as our Nagaland state is concerned. And during this favorable season, lordship, we'll be able to complete it.
Mm. Yes, anybody for the petitioner side?
Lordships, I'm appearing on behalf of my senior. He's not here today.
Is,
He's the out station. Amicus Curie.
acha. Your good name
Viketsono.
is Vicky Sonam, Learned Counsel, appearing on behalf of Mr. A. Jimomi,
Yes, Lordship.
the Learned Amicus Curie. Submits that Mr. Jimomi is out of station.
Yes, Lordship.
Is out of station. The Learned Counsel for the respondent number 1. Who is for 1?
1, 2, and 8, Lordship.
1, 2, and 8.
Lordship.
Your name, please.
Moajamir, Lordship.
Moazamir, present, and Learned Counsel for the respondent number 3.
I'm appearing on behalf of Indian Song, additional AG.
Inti Imsong. Your good name?
LD Sangam.
Learned Counsel for the Learned Additional Advocate General, Mr. I. Imsong.
Yes.
For the respondent number 7,
3, 7, 11, and 12.
3, 7, 11, and 12. And Mr. Joshua Seki, Learned Counsel for the respondent number 9.
Yes,
And
Lord.
Mr. Santi Iyengar, Learned Counsel for the respondent number 10, present. Person to order dated 18/10/2023. The respondent number 9 and respondent number 10 have filed their respective affidavits. We have gone through filed the respective affidavits indicating the progress achieved by the respondents in the meantime. Mr. Seki, Learned Counsel for the respondent number 9, submits that. Though the progress achieved by the respondent number 9 is 51.54%.
Yes, my lord.
Yet, in fact, the progress achieved by it is more than 70%.
No, almost 70%.
Almost
Lordship.
70%. Almost 70%. And that the achieved by the respondent number 9 is 50. The respondent number 9 will be able to complete the project before March 2024.
Yes, Lordship.
Though the deadline is given as March 2024 by this court.
Not by this court, Lordship.
By-
By the authorities,
by the
March,
authorities.
March 31st,
By the
2024.
authorities.
So we will try to finish before that, Lordship. We'll make an effort to finish before that. Lordship.
And before that day, the respondent number will try to finish the work. Whereas Mr. Santi Iyengar, Learned Counsel for the respondent number 10, submits that the progress achieved by the respondent number 10 is 49.27%.
Respondent number 9, progress achieved by the respondent number 9.
No,
Because he
sorry.
the contractor.
The 10 is 49.27%.
27%.
20%. However, there is little variance between the progress achieved by respondent progress shown in the affidavit of the respondent number 9 and the respondent number 10. Why this variation is there?
Lordship, I am only including portions that are fully completed, whereas he is including portions that are
Under
actively
progress.
under progress.
Hmm.
So, which is why the work under progress that he has included
Is more.
is more.
Uh, uh, there is little variation in the affidavit of respondent number 9 and respondent number 10, as the respondent number 10 has shown the progress of the work which has already been completed,
My lord.
and the respondent number shown on 9 has shown the progress of the work which is going on.
Yes, Lord.
Which is going on. Having produced the affidavits, and now we have gone through the affidavit submitted by the respondent number 9 and 10. 9 and 10. So what order is to be passed today?
Lordship may kindly fix a next date where we will again file our progress report.
In view of the submission of learned advocates of both sides, sorry, advocates of respondent number 9 and 10, and also in view of the affidavit submitted by them, and having been satisfied with the progress achieved in the meantime, this court is inclined to direct the respondent number 9 and 10 to file affidavit indicating the progress of work undertaken by them when
After the winter vacation, madam.
after the winter vacation. So do
If
you
a
fix
date,
that
if a date is to be fixed, Lordship, 24th January,
24th January?
my lord.
Is it working day?
Yes,
Yes,
Lordship.
Lordship.
It's a
Okay.
Wednesday.
Okay. So any submission from other respondents?
Since the affidavit is filed by the authority engineer, Lordship,
Yes.
will adopt the affidavit filed by the authority.
Okay.
Lordship.
Rest are listed on 24th
January
January
2024.
2024.
My lord. Lordship.
For admission, item number 4.
I have received the affidavit in opposition just yesterday. So I'm given some time to go through the affidavit and let this matter be listed after the vacation.
Who's for the
My
petitioner?
Item four.
I am for the respondent, my lord.
Yes.
I am for the respondent.
Yes.
My lord, the case may be fixed on 31st January for final hearing.
Final hearing.
Item four.
Final hearing, my lord, 31st January.
Your good name, please?
A. Ahmed. A. Ahmed. Adil Ahmed.
You are for the
Respondent, sole respondent, private respondent.
Mr. So-and-so, learned CGC, on behalf of the petitioner, with consent from the other side, press for listing the matter on. When?
Since it's one more station and that
Yes, Mr. Ahmed, when it is to be fixed?
31st January.
31st January. 31st January. So as to enable him to file. Yes, learned CGC. You will file objection?
yes, ma'am, if necessary.
So as to enable him to file objection if necessary. Here is accordingly allowed. Rest is the matter on 31st of January 2024.
For admission, item number 5.
Obliged.
Lordship, on behalf of the unit of India, I may give you some time to file my affidavit in opposition. The affidavit is being
Mr. So-and-so, learned CGC, price for granting him some more time to file affidavit in opposition.
Well,
Affidavit in opposition. The pairs who made is not objected by
Libani Bijou.
learned counsel for the petitioner.
Yes, Your Lordship.
Petitioner. Pair is accordingly allowed.
For admission, item number
Lordship.
6.
Lordship, here, the petitioner, they have wrongly implicated the Union of India. So they have to make some correction in the ministry.
Yes,
Lord-
madam.
Yes, Your Lordship, if that's the case, then kindly grant us some time to implement the appropriate authority, Your Lordship.
Acha. Your good name, please?
Limika Kinimi.
Miss Limika Kinimi, Learned Counsel for the petitioner.
Yes, Your Lordship.
For the petitioner submits that she may be granted some time to implement appropriate authority. That authority as a party in this rate proceeding. Two, three, and 4. Pair of Miss Kinimi is accordingly allowed. Learned Counsel, Miss Counsel for the respondent number 2, 2 and 4. Miss, your good name? Apila Sanctum is present.
Lordship, the respondent number 7. This is not the respondent 2. If the respondent number 7 be the name of the respondent number 7 may be deleted.
Yes, any objection?
No, Your Lordship.
They has been wrongly implicated.
Miss, Mr. So-and-so, Learned CCC submits that the petitioner has impleted the respondent number 7, though he is not a necessary party.
If
here
my
in this-
lordship may kindly give the full particulars also. The
Respondent number 7, the
Ministry of-
Secretary, Ministry of Social Justice and Empowerment, Sasti Bhavan, C Wing, Dr. Rajendra Prasad Road, New Delhi, is not a necessary party. And price for deleting the name of respondent number 7 from the array of this petition. The pair so made by the Learned CCC is not objected by the petitioner. Learned Counsel for the petitioner. Accordingly, the pair of Learned CCC is then allowed. The name of respondent number 7 be deleted from the array of this petition. List after
Vacation, Your Lordship.
after vacation.
Yes, Your Lordship. Much appreciated.
For admission, item number 10.
Lordship, in this case, I have not received any instruction, so I will give it some time. I have not received any instruction in this case. I am for the Union of India.
Mr. So-and-so, Learned CCC, appearing on behalf of the Union of India, submits that he have not received any instruction and price for granting him some more time here is accordingly allowed. Learned,
Your Lordship, I'll also be filing my affidavit in reply to the affidavit in opposition filed by respondent number 3, 4, and 5, Your Lordship.
you are for the petitioner.
Yes, Your Lordship.
Miss So-and-so, Learned Counsel for the petitioner present and submits that she has filed affidavit in
No, Your
reply.
Lordship, I'll be filing it. Yes,
He
Your
will be,
Lordship.
she will be filing affidavit in reply.
Yes, Your Lordship.
To the affidavit in opposition submitted by,
Respondent number 3, 4, and 5, Your
filed by
Lordship.
respondent number 3, 4,
4
and
and 5. Yes,
5.
Your Lordship.
Here is accordingly. Yes,
For respondent number 2.
respondent number 2, Mr.
AL.
Pardon?
AL.
AL,
Yes, ma'am.
Learned Counsel for the respondent number 2 and Mr.
For R3, 4, and 5. Respondent number 3, 4, and
Learned
5.
Counsel for the respondent number 3, 4, and 5 present.
We file our
Present. Yes. List the matter after
Yes,
After vacation, Your
after
Lordship.
vacation. After vacation.
Yes, Your Lordship.
For admission, item number 12.
Lordship, I have received the affidavit. I'll be filing my affidavit within 2 or 3 days. Let it come up next week.
May I please, Lordship?
Yes.
My Lord, I'm appearing for respondent number 1 to 4. Kindly allow me 2 weeks time to file a petition.
1 to 4.
Yes. 1, 2, 3, and 4 for the state respondent.
And Mr. CCC, you are for? The respondent number?
5, 5.
5. Who is for the petitioner? None appears for the petitioner on call. However, Mr.
E.T. Papom.
Perhaps Lordship.
Yes.
At number 12, Lordship, we have received the confirmation order for another 3 months. Lordship, may be allowed to file an IA to amend the petition. So which time, Lordship?
You are for the petitioner.
For petitioner, Lordship.
Petitioner.
Lordship.
This WPC criminal
The
10,
WPC criminal 10,
2023. You are for
it's
the
a-
petitioner.
Lordship, it's a habeas corpus
Yes.
NEC detention. So if we have received the confirmation order.
Acha. You will be filing one IA.
So I may be allowed to file an IA to amend the petition, Lordship.
Acha.
As per the Gauhati High Court rules, is that is
Heard
the
Mr. Fosiko Pote,
that's
Learned
position.
Counsel for the petitioner. Mr. Pote submits that he has received the confirmation order from the respondent number. From the respondent number, you keep it.
From the
And
home department, Lord.
pardon?
Home department. From state council.
From the state respondent and
Respondent 3.
respondent number 3, and he will file an IA interlocutory application for according him permission to amend the petition. There is accordingly allowed. Mr.
E.T. Papom.
Learned Counsel for the respondent number 1 to 4 and Mr.
1, 2, 3, and 4.
Yes, 1 to 4. Yes. And Mr. Learned CGC for the respondent number 5 present and praise for granting them time to file affidavit in opposition.
Yes, ma'am.
There is accordingly allowed. List the matter. After-
Next week, Lord.
Next
Next
week.
week, Lordship. I'll
Next
file
week.
it in the week, Lordship.
Next week.
Lordship.
Then you have to wait for filing the amendment petition.
Yes, ma'am. Much obliged.
For orders, item number 13.
May it pleases your lordship. My lord, this appeal is against the judgment and order dated 4/7/2020. On the last occasion, notices were issued, my lord. And the respondent number 1 to 3, who were the petitioners in the petition.
1, 2, 3, and 6.
6.
Yes.
My lord,
Your
I was
Lordship,
told my learned friend appears
I'll be
for
appearing
1.
for the respondents 1, 2, 3.
1, 2, 3.
Yes.
Acha. Acha.
My lord,
So you have filed local law number?
Yes, I have. It has been reflected in the process.
Acha. Acha.
Fine.
Acha.
Healthy rather.
Yes.
Insofar as respondent number 6 is concerned, my lord,
Yes.
although we had taken steps with the municipal corporation, the
Yes.
steps were taken on the correct address.
Yes.
And almost 1 month would expire tomorrow or day after.
Yes.
But they have not appeared. I pray, my lords, otherwise lordship may deem service. But if your lordship allows me, I'll serve dusty notice on the respondent number 6.
Okay.
Because, my lords, there's some urgency in the matter, my lords.
Yes.
I kindly pray, my lords, on the next day,
Mm.
the lordship may be, the matter may be taken up for disposal, my lords. Kindly, my lords.
Mm. Heard, Mr. Your good name?
T. Mohanto, my lords.
T. Monto,
T.
Learned
Mohanto.
Learned Counsel for the petitioner.
For the appellant.
No, for the appellant. And Mr.
L. Iralu for the
L.
respondents
Iralo,
1, 2,
Learned
3.
Counsel for the respondent number 1, 2, and 3.
Yes, Your Lordship.
1, 2, and 3. And Ms. Sukari, Learned Senior Government Advocate. Senior Government Advocate. Additional AG. Okay, sorry. Learned Additional AG. Present for the respondent number 4 and 5. 4 and 5.
7 and 8, the CGSE appears, my lords. 7 and 8 respondent.
7 and 8. So none address for the respondent number 7 and 8.
Yes, ma'am.
Mr. Mohanto, Learned Counsel for the appellant submits that. So what was your submission?
My lords, there's some urgency in the matter.
To
Although
serve
we had
the-
taken steps on 2nd, We'll again take substituted service on respondent number 6 by way of Dusty Malloch. This honorable court allows.
Mr. Monto, learned counsel for the petitioner. The appellant submits that though he has taken step upon respondent number 6, yet no report has been received. No report has been received by the registry as indicated in the office note dated 24/11/2023, and as such Mr. Mohanto submits that he may be allowed to take step upon respondent number 6 through Dusty mode. Thereof Mr. Mohanto is accordingly allowed.
Since
List
this-
the matter on when
17
17th of
January.
January, my lord.
17th
Lordship
January.
would fix it for
And on
admissions,
that
my
day,
lord. Admissions.
an
admissions,
endeavor
my
will be made to dispose of the matter
lord. Very
finally.
grateful.
For hearing, item number 18.
Yes.
Lordship, here the petitioner, the read petitioner, he is a Rochas employee. He worked as a fixed paid labor. Then he was promoted with effect from 30/9/2019. So he prayed he made a representation to the department for the regularization of his service. And his representation was not considered by the department, for which he filed WPC number 21 of 2021 before this honorable court, praying for regularization of his service. And the learned single judge by the impugned judgment, your lordship, that is at page 82. The relevant portion is at page 86, your lordship. I may be allowed to read.
86 of your affidavit.
Of the appeal memo.
Acha.
The judgment starts from page 82 and the operation part is at page 86.
Yes.
Para 6.
Yes.
I have considered the submission of both the learned counsel, keeping in view the facts and circumstances which have not been disputed. The pay of 380 Borchardt employees, majority of whom were junior to the petitioners, were upgraded to scale of pay by the department, leaving aside his case. In spite of the application submitted to the respondent number 3, the service of 195 persons who were all junior to the petitioners were regularized, and that too without meeting the requirements of the provision of the office memorandum referred to by the learned government advocate. Though all this happened after the retirement of the petitioner, I am of the view that the petitioner has been discriminated since the petitioner had served the department without any break for so many years. He should have been given the same benefit when he had asked for it. Even without asking the state as a model employer and under a democratic form of government, and being a welfare state should have done it. Having not done so, amounts to exploiting its own citizen for 35 years and releasing him empty-handed. The fact that his service was utilized till he completed his 5 years of service, by which any person serving under the government of Nagaland is to retire, shows that his service was not only required but fully utilized. If a person's service is required and utilized, he should have been given what he deserved. 7. It has been submitted by the learned counsel for the petitioner that the petitioner, when he retired, enjoyed only rupees 3,450 per month as pay. It is difficult to imagine how he would have struggled all his life to look after his family members. After having led such a life, to let him go empty-handed cannot be reasonable. Slavery and forced labor are things of the past, but it appears that for some people they still suffer for such practices. Therefore, in similar cases such and such, this court on 24/3/2022 had allowed the prayer of the persons who are similarly situated as the petitioner and directed the state government to consider regularization of the services for pension and pensionary benefit. Taking into view the order passed in those now with petition and the order of the Honorable Supreme Court given above, this court is of the view that the case of the petitioner praying for regularization of his service so that he may enjoy pension and pensionary benefit is a legitimate prayer. 9. In view of all that has been stated above, the writ petitioner is hereby disposed of with a direction that the respondent should regularize the petitioner's service within a period of 4 months from the date of receipt of order of this order, so that he will at least enjoy pension and pensionary benefit after all those years of dedicated service rendered to the state. So here, Your Lordship, the learned single judge has directed the state to regularize the service of the petitioner, who is a ward charge fixed employee. So Your Lordship, the ward charge employees, they are governed by the Casual Employees Regulation Act. That is given that Your Lordship. Lordship may come to page 110. Page 110.
Yes.
The Nagaland Ward Charge and Casual Employees Regulation Act 2001. Then at page 111, the definition of ward charge, that is at close to D. Ward charge employees means an employee engaged without sanction post under ward charge employees. So they are an employees without engaged without on a not on a sanction post. Then Your Lordship may come to page 114, section 12. Section 12, scheme for absorption of service. The state government may draw up a scheme for absorption of service of ward charge employees into regular government service. So Your Lordship, the act has given empowered the state to bring up the scheme. So accordingly, the state has got two schemes. Your Lordship may come to page 89 of my appeal memo. This is the scheme.
Now, whether the office memorandum of 17/3/2015,
yes,
whether that memorandum, office memorandum, will cover the case of the petitioner?
That does not cover, because in that case, the ward charge employee should be enjoying a scale of pay. But the petitioner is not on scale of pay, he is on fixed pay. So when he is on fixed pay, the office memorandum 2290,004 covers his case. But he should fulfill some criteria, Lordship. Yes. Lordship, page 89, that is the scheme of 2004.
89 of your affidavit?
Yes, of my appeal.
Page number?
89 of my appeal memo.
Yes.
Yes. Lordship, this is office memorandum dated 22 September 2004. Policy and scheme for regularization or service of ward charge employees. There are a large number of ward charge employees in this department. Many of these employees have been serving continuously for many years. They have been represented to the government for regularization of their service. Some departments have been regularizing the service of ward charge employees from time to time against available vacancies. However, no transparent and rational policy and criteria is discernible in the process of regularization of service of ward charge employees. Therefore, in order to examine the issue of regularization of ward charge employees in various departments, the state government set up a committee under the chairmanship of Sri Lautara IAS, Additional Chief Secretary, Geology and Mining. On the basis of the recommendation of the Committee for Regularization of Ward Charge Employees in the state, the government hereby adopts the following policy and scheme for regularization of the service of ward charge employees serving under various departments of the state government. 1. Each department having ward charge employees shall maintain a list of ward charge employees in various categories in order of their length of service. 2. Regularization of overcharge employees will be done against available regular vacancies. Number three, 50% of all regular vacancies of similar nature arising in a year will be reserved for regularization of overcharge employees, and the remaining 50 will be filled up as per normal rules of recruitment. Four, overcharge employees will have the right to be considered first for regularization against 50% of all future vacancies of similar nature in the department for which they possess the requisite qualification. Such regularization will be considered on the basis of seniority cum merit. This means that the senior-most overcharge employee in the relevant category will be regularized, subject to his or her fitness for the vacant post. So, Your Lordship, only when there is a vacant post, and if the petitioner is in the senior-most in that category, he will be considered for regularization as per this memorandum. The petitioner has to be a regularization has to be on the basis of seniority, Your Lordship. Then Lordship may come to page 91. This is the seniority list at the time of his retirement. Government of Nagaland Public Health Engineering Department, Nagaland, Kohima, overcharge fixed pay labor seniority list as of July 2019. Then the next page, Lordship, 92, the petitioner name appear at serial number 9. Name of division, Mon, name unpaid, Lordship. So Your Lordship, he is not the senior most in his category as a fixed pay laborer. There are so many, there are 8 persons senior to him. All these persons also have not been regularized, Your Lordship. And they have retired. So even the petitioner, he is not the senior most. So he cannot be considered under the OM 2004. And he does not come under the OM 2015 because the OM 2015 clearly says that the person should enjoy scale of pay and he should serve for more than 30 years. For Your Lordship appraisal, that is at page 45.
No, yes, I'm aware of this.
Yes. So Your Lordship, the direction that was given by the learned single judge to direct the state respondents to regularize the petitioner, Your Lordship. There is a perversity in the order. And the petitioner is relying on the RTI reply that is at page 56. After his retirement, he sought for an RTI reply, Your Lordship, where the RTI reply has given that some of the overcharge employees, they were regularized. But all these persons, Your Lordship, they are enjoying scale of pay and they are similar to the petitioner. Yes. So before the petitioner retired, they were regularized, and even after the retirement of the petitioner, they were regularized. So the petitioner is not similarly situated with all those 380 overcharge employees. And in regard to Your Lordship, the other (31) members, Your Lordship, that is at page 56.
56 of?
Yes, of my appeal.
Yes.
Yes. So Your Lordship, here, this is the administrative approval. This is order dated 23 July 2028. This was passed after the retirement of the petitioner. This is given by the government to the Chief Engineer Sanitation administrative approval for upgradation of fixed pay to scale of pay. I am directed to refer to letter number such and such 55/2020 and to convey herewith the administrative approval for upgradation of fixed pay level to scale of pay in respect of 31 employees who have completed 30 years or more as on 1/7/2020. Further, the fixed pay employees who has retired on or before 1st January 2020 shall not have the right to claim scale of pay. So, Your Lordship, it's very clear that this order is passed after the petitioner's retirement, And the letter also clearly says that those who had retired before 1st January 2020, they shall not have the right to claim. Petitioner neither challenged this order in the writ petition, neither impugned this letter. So when this letter was never impugned, the learned single judge ought not to have entertained the writ petition, Your Lordship. And regarding with the other writ petitions, bundles of writ petition which the petitioner relied and the learned single judge has reflected in the order, Your Lordship, all those there was not a direction to the government. All those were directions were only to consider the case of the petitioner. So the discretion is left to the government to decide, Your Lordship. So, Your Lordship, when the petitioner, he does not come within the policy of the government, directing the state to regularize the petitioner is impermissible in law. And a sympathy cannot be the ground to take what is different from permissible in law, Your Lordship. And Your Lordship knows very well that no mandamus can be directed against the state to act contrary to the law. So we have the statutory rules, that is the Work Charge and Control Practice Regulation Act, Your Lordship, where it clearly says that the work charge employees are not holding a sanctioned post, Lordship. And the petitioner, he does not fulfill the criteria laid down in OM 2004 because he stands at serial number 9. He's not the senior most.
No, Madam, what is the criteria for granting this scale of pay?
Your Lordship, there is no criteria as such, Your Lordship.
Then why the petitioner, he had not been granted the scale of pay during his 30 to 34 years of service?
Your Lordship knows the scale of pay is attached to a post. So when the petitioner is not holding a post, there cannot be a scale of pay, granting of scale of pay. So even the granting of the scale of pay, that is by mistake, Your Lordship. And a mistake committed by the state, the petitioner cannot claim the similar benefit. Otherwise, if
right.
it claim, it will be a perpetuity of illegality, Your Lordship. Yes, because a Lordship knows that scale of pay is attached to a post, a definite post. So when the petitioner are not holding
No, whether there's 31 employees who have completed 30 years,
yes,
they have been granted scale of
Yes.
pay and against a post?
No, Your Lordship. So, Your Lordship, that was an error. That
Which
was
one?
that granting
This-
of scale of pay to the 31 employees, work charge regularization, because there is no policy of the government. So what I'm saying is that I had earlier submitted also petitioner never challenged that letter.
No, admitting that this is a wrong, this is a wrong policy decision.
Your Lordship, as per the government policy, we have no scale of pay, Your Lordship. There is no policy for granting scale of pay to a person who is not holding a sanctioned post, Your Lordship. But this is the way how the
When the petitioner retired, no, when the respondent number 1 or retired,
he retired on 30/9, 2019.
19.
Yes, he retired on 2019. So even those persons, Your Lordship, I have shown who are senior to him also retired without any benefit, pensionary benefit. It is only the petitioner who is approaching this court asking for regularization of his service, Your Lordship. Yes. So, Your Lordship, and Your Lordship, in a similar case, that is page 94. That is judgment. Page 94. This is the judgment vehicle. 2022. Passed in the state of Nagaland and other verse Nishivi Achunu. Page 94, Your Lordship. I think you're allowed to read. Feeling aggrieved and dissatisfied with the impugned judgment and order dated 19/4/2021, passed by the High Court of Gauhati at Kohima in writ appeal such and such, by which the division bench of the High Court has dismissed the said appeal and has confirmed the judgment and order passed by the learned single judge, directing the appellant state to regularize the services of the deceased husband of the respondent from 1 day earlier to his death and thereafter to pay the family pension to the respondent. The state has preferred the present appeal. Then Lordship may come to the operative portion, that is page 98, paragraph 4. page 98, paragraph 4. Having heard learned counsel for the state and considering the submission made on behalf of the state and having gone through the judgment and order passed by the learned single judge, confirmed by the division bench, we are of the firm opinion that the High Court has committed a grave error in directing the appellant to regularize the services of the deceased employee 1 day prior to his death. 4.1. It is required to be noted that the deceased employee died in the year 2005. During his lifetime, he never claimed any regularization. That the respondent herein, original writ petitioner, wife of the deceased employee, claimed the regularization after a period of 12 years from the death of the deceased employees. At the time of the death of the deceased employee, he was not entitled to regularization as he was much below in the list of the ward charge employees whose services were to be regularized. So if we took this one, Your Lordship, the petitioner at the time of his the present writ petitioner at the time of his retirement, he stands at serial number 9. Under the regularization policy, the services of the ward charge employees were required to be regularized as per their seniority and as and when the vacancy arises. The services of the other ward charge employees, even who were senior to the deceased employees, were regularized in the year 2009 after the death of the deceased employee. Despite the above, the High Court has directed the state to regularize the services of the deceased employee 1 day prior to his death, which otherwise his services were not required to be regularized, as his turn had not come and he was much below in the seniority list. 4.2. Considering the aforesaid facts and circumstances, the impugned judgment and order passed by the High Court is unsustainable and the same deserve to be quashed and set aside. 5. In view of the above and for the reasons stated above, present appeal is allowed. The impugned judgment and order passed by the division bench of the High Court as well as the learned single judge is hereby quashed and set aside. Consequently, the original writ petition filed by respondent wife herein stands dismissed. However, in the facts and circumstances of the case, there shall be no order as proposed. So even here, Your Lordship, instead of Nagaland versus Nishibi also, the Honorable Supreme Court has also clearly stated that the petitioner does not come within the purview of the regularization because, Your Lordship, he is not the senior most and as per the policy of the government. Then, Your Lordship, the Supreme Court has stated that regularization can be made only as per the regularization policy of the state government. That is 2021 ACC online AC 899. Lordship. Lordship, this is Unit of India and others was Ilmo TV and another. Lordship, paragraph 25. 25.
Yes.
Yes. The observation made in paragraph 9 are on summarizes and conjuncture. Even the observation made, they have worked continuously and for the whole day are also without any basis and for which there is no supporting evidence. In any case, the fact remains that the respondents served as part-time employees and were contingent paid staff. As observed above, there are no sanctioned posts in the post office in which the respondents were working. Therefore, the direction issued by the High Court in the impugned judgment and order are not permissible in the judicial review under Article 226 of the Constitution. The High Court cannot, in exercise of the power under Article 226, issue amendments to direct the department to sanction and create the post. The High Court, in exercise of the power under Article 226 of the Constitution also, cannot direct the government and or the department to formulate a particular regularization policy. Framing of any scheme is no function of the court and is the sole prerogative of the government. Even the creation and or sanction of the
Madam, here the question is sanction and creation.
Yes,
but in
so-
the present case, there is only regularization.
So, Your Lordship,
So how this judgment will help you?
No, the following paragraph, Your Lordship. Even the creation and or sanction of the post is also the sole prerogative of the government, and the High Court, in exercise of the power under Article 226 of the Constitution, cannot issue mandamus and or direct to create and sanction the post. 26. Even the regularization policy to regularize the services of the employees working on temporary status and occasional laborers is a policy decision, and in judicial review, The court cannot issue mandamus or issue mandatory direction to do so. Then 27. In the case of Dayan Lal Supra in paragraph 12, it is observed and held as under. We may at the outset refer to the following well-settled principles relating to regularization and parity in pay relevant in the context of this appeal. 1. The High Court, in exercising power under 226 of the Constitution, will not issue direction for regularization, absorption, or permanent continuance unless the employees claiming regularization had been appointed in pursuance of a regular recruitment in accordance with relevant rules in an open competitive process against sanctioned vacant posts. The equality clause contained in Article 14 and 16 should be scrupulously followed, and the court should not issue a direction for regularization or services of an employee which would be violative of the constitutional scheme. While something that is irregular for one of compliance with one of the elements in the process of selection, which does not go to the root of the process, can be regularized, backdoor entries, appointment contrary to the constitutional scheme, and or appointment of ineligible candidate cannot be regularized. 2. Mere continuation of service by a temporary or ad hoc or daily wage employees under cover of some interim orders of the court would not confer upon him any right to be absorbed in service. As such, service would be litigious employment. Even temporary ad hoc or daily wage service for a low number of years, let alone service for 1 or 2 years, will not entitle such employee to claim regularization if he is not working against a sanctioned post. Sympathy and sentiment cannot be ground for passing any order of regularization in the absence of legal right. 4. 3. Even where a scheme is formulated for regularization with a cutoff date, that is a scheme providing the person who had put in a specific number of years of service and continuing in employee as of the cutoff date, it is not possible to others who were appointed subsequent to the cutoff date to claim or contend that the scheme should be applied to them by extending the cutoff date or seek a direction for framing a fresh scheme providing for successive cutoff date. Then, Your Lordship, 29. Applying the law laid down by this court in the aforesaid decision, the direction issued by the High Court in the impugned judgment and order, more particularly direction in paragraph 22 and 23, are unsustainable and beyond the power of judicial review of the High Court in exercise of the power under Article 226 of the Constitution. Even otherwise, it is required to be noted that in the present case, the Union of India Department subsequently came out with a regularization policy dated 30/6/2014, which is absolutely in consonance with the law laid down by the court in the case of Umar Devi Supra, which does not apply to the part-time workers who do not work on the sanctioned post. As per the settled preposition of law, the regularization can be only as per the regularization policy declared by the state government, and nobody can claim the regularization as a matter of right, divorce the regularization policy. Therefore, in the absence of any sanctioned post and considering the fact that the respondent was serving as a contingent paid part-time Safai Karamcharis, even otherwise they were not entitled for the benefit of regularization under the regularization policy dated 30/6/2014. So, Your Lordship, even here also Supreme Court has clearly stated that regularization has to be as per the regularization policy. The division bench of this honorable court has also passed a similar judgment dated 8/6/2023. In the state of Nagaland versus Alemba, dated 8/6/2023. Lordship, I may be, take you to page 13, paragraph 11. Page 13. The ratio laid down in the case of Srimati Maggie H. Desai Supra, as well as Nishibi Achumi Supra, in our opinion, squarely covered the present case. It is no doubt correct that the respondent has rendered more than 20 years, 6 years of service as a ward charge employee, and therefore, as a model employer, the state was duty bound to come up with a policy decision. So here, Your Lordship, here in this case, the petitioner is a fixed, is a ward charge employee on scale of pay. In this appeal, Your Lordship, the state has a duty bound to come up with a policy decision and a scheme for regularization of services of such ward charge employees. However, as would be evident from the facts alluded, the government of Nagaland did come up with not only one, but as many as two schemes. Unfortunately, the respondent did not meet the requirements of either of the schemes. That is the reason why his service was not regularized. Therefore, it cannot be said that the state has meted out a discriminatory treatment to the respondent by declining his request for regularization in service. 12. It is also to be noted here that the respondent had never made a prayer for regularization of his service prior to his retirement. The representation was submitted only after he had retired from service, and that too only for the purpose of receiving pension. The matter could have been considered from a different angle had the respondent met the requirement of the scheme and had approached this court seeking regularization prior to his retirement. At this stage, consideration of the prayer made by the respondent may call for creation of a supernumerary post for regularization of his service, which would not be permissible in the fact of this case. In the case of Union of India and others versus Ilmo Devi and another reported in such and such, the Honorable Supreme Court has held that the High Court, in exercise of power under Article 226 of the Constitution, cannot direct the state government to sanction and create posts for regularization of part-time employees. Framing of any scheme is not the function of the court, but is the sole prerogative of the government. Even creation and sanction of posts are also the sole prerogative of the government, and the High Court, in exercise of power under Article 226 of the Constitution, cannot issue mandamus to that effect. 13. Law is firmly settled that right to receive pension is strictly governed by the provision of the relevant rules, which in the present case is the rules of 1972. The question of payment of pension would arise if the employee is substantially appointed against a sanctioned post. 14. The terms of appointment and conditions of service of board charge and casual employees in the state of Nagaland is governed by the Nagaland Board Charge and Casual Employees Regulation Act 2001. Section 2D of the Act of 2001 defines board charge employees, which means an employee engaged without sanctioned post under board charge establishment. As per Section 6 of the Act, board charge employees will be entitled to be paid wages as may be prescribed by the state government on consideration of recommendation made by the commissioner. However, in case of board charge employees who were paid scale of pay at the time of commencement of the Act, their pay would not be less than the last pay as may be determined at the time of prescribing the fixed wages. From the above, it apparent that the Act of 2001 seeks to protect the last drawn wages pay scales of board charge employees. 15. There can be no doubt about the fact that with the enactment of the Act of 2001, the conditions of service of board charge employees in the different board charge establishment in the government of Nagaland would be governed by the provision of the said Act. The Act of 2001 neither confers any right to seek regularization in service, nor does it extend pensionary benefit to board charge employees. Unless a board charge employee's scheduled employees is regularized against a vacant sanctioned post and fulfills the requirement of minimum qualifying service as a regular employee, the question of payment of pension would not arise in the eyes of law. In the present case, even if the ex post facto regularization is given to the petitioner, even then he will fall short of the minimum qualifying service under the rule so as to be entitled him to receive pension. 16. As has been observed here in above, the claim of the respondent for receiving pension does not come within the scope and ambit of Act of 2001. Although Mr. Lonjar has placed heavily reliance on the provision of rules of 1972, so as to contend that the respondent is entitled to receive pension. The fact remains that as per Rule 2B of the rules of 1972, person in casual and daily rated employees have been excluded from purview of rules of 1972. As such, the respondent clearly does not come within the ambit of the Act of the Rules of 1972 for making out a case for payment of pension. The OM issued by the central government bearing numbers such as such relied upon by the learned counsel for the respondent would also not be applicable in this case. That apart, the approach of learned single judge in the present case also appears to have been clearly disapproved by the Supreme Court in the judgment in Nishivi Atuli Supra, rendered in more or less identical fact situation. Therefore, the direction issued by the learned single judge, in our opinion, is untenable in law on such account alone. 17. Before parting with the report, we deem it appropriate to note herein that the decision relied upon by the learned counsel for the respondent have been considered. In the case of Prem Singh Supra, The Honorable Supreme Court had interpreted Rule 38 of the UP Retirement Benefit Rules 1961 and Regulation 370.
So, Madam, this is not
Yes.
relevant.
Yes. So, Your Lordship, accordingly, Your Lordship, page 17, the last para, for the reasons stated here in above, we are of the unhesitant opinion that the impugned judgment and order passed by the learned single judge is unsustainable in the eye of law, and the same is accordingly set aside. The writ appeal is allowed, and the writ petition is dismissed. So, Your Lordship, this honorable court has also the court which I relied upon squarely covers the case of the petitioner. There cannot be a regularization when the petitioner does not meet the regularization policy of the government. So my prayer is that Your Lordship to quash and set aside the judgment and order dated 11/4/2022 passed in WPC 21 of 2021, Your Lordship, and dismiss the writ petition. That's my prayer. Much appreciated.
Yes.
May I please, my lords? Lordships, since this is the last item for today, Lordship, I may kindly be given some liberty to canvass my case, Lordship. Now, my lord.
No, we have already gone to the judgment of the learned single judge.
Yes, my lord.
Ah.
Yes. In fact, Lordship, the facts are undisputed. I was appointed in 1984, retired in 2019 after serving for 35 years as work charge labor, Lordship, under the PhD department. Now, Lordship, the act that has been passed, if I may be kindly allowed to take my lords to the act, the object of the act, the title of the act, my lord, firstly, the Nagaland Work Charge and Casual Employees Regulation Act 2001.
Yes.
I want to make out the case that, my lords, this regularization of the present petitioner is squarely covered under this scheme, Lordship, under this act, which has statutory force. And the office memorandums that were issued by the state government from time to time, the policy for regularization, those can only supplement this principal statute. It cannot supplant it, my lords. Now, the object, my lord, an act to regulate appointment and conditions of service of persons appointed as work charge employees and casual employees. Now, my lord, conditions of service, I believe, in my humble opinion, it includes regularization as well. The definition, Lordship, that has been provided under section 2D of the I may be allowed to read it, my lord. Work charge employee means an employee engaged without sanctioned post under work charge establishment. Now, my lord, section 12. This provision as well as section 12 may be read together, my lord. It may be read harmoniously, my lord.
Scheme for absorption of
Yes, scheme for absorption of service.
Yes.
The state government may throw up a scheme for absorption of service of work charge employees into regular government service. Now, my lord, the harmonious reading of section 2D as well as section 12, we can make out that the state government intends, the intention of the legislature, my lord, is to regularize the work charge employees without sanctioned posts. Now, in fact, under the 2015 scheme, my lord, which has been also relied by the learned government advocate, lordship, under provision 1, Roman 1, it reads as under, I may be allowed to read this, lordship. All this may be read together, lordship. Regularization in service.
This
2015 scheme.
Yes.
My lord.
You have enclosed it with your.
No, Lordship, the writ appellant, they have enclosed it in
At
their
page
writ appeal
number-
memo at
page
page
number.
45.
45.
Yes, my lord. The 2015 scheme.
Yes.
1 Roman 1, my lord. All existing work charge and casual employees of various departments who are enjoying scale pay and who have completed 30 years or more continuous service as on 1/1/2015 will be regularized by conversion of their posts into regular ones personal to them and subject to fulfillment of conditions as indicated below. So, my lord, it does not, the scheme as well as the act, it does not envisage existence of sanctioned posts for my regularization, my lord. As soon as I complete 30 years and as soon as I receive scale of pay, lordship, I am to be regularized.
No, here the problem is you have not been granted the scale of pay.
I'll come to that, my lord. I'll come to that, my lord. Because, lordship, if they have awarded the scale of pay in a fair manner, lordship, those 380 employees, lordship, in fact, misleading submission has been made, lordship. They are all junior to me. The date of appointment is clearly indicated in the RTR reply. I am appointed in the year 1984. Those employees are appointed only after 1984, lordship. All 380. And those 195 who were regularized, those are also all junior to me. All 195, lordship. So if they have awarded the scale of pay, lordship, in a fair manner, lordship, as a model employer, then I would have been awarded scale of pay a long time ago when I was in service, lordship. And in fact, I have also made a representation to the state government while I was in service. It was not considered, it fell upon deaf ears.
Whether that petition was representation was part of your petition?
Yes, my lord. I have annexed in my
reply.
No, my lord. In my writ petition.
Writ petition.
Yes, my lord. Now, lordship, this act, lordship, it is a beneficial act, and the scheme that has been drawn is a beneficial scheme intended to benefit the work charge employees and casual employees employed by the government of Nagaland. So, lordship, as laid down by the Honorable Supreme Court, lordship, in AIR 1961 SC 647, lordship.
1961, page number?
647. The title of the case is Olympic Chemical Works Company Limited versus Workmen.
Olympic Chemical versus?
Olympic Chemical Works Company Limited versus Workmen. The relevant paragraph is at para 7, lordship. Page 649, lordship. Page 649, lordship. The judgment starts from 647. The relevant paragraph is at 649. The last paragraph 7, at 649. Towards the bottom of the page, my lord.
Yes.
Even on the basis that section 79(1) is capable of the construction sought to be placed on it by the appellant, the question would still remain whether the said construction should be preferred to the alternative construction, which as we have just indicated, is reasonably possible. The answer to this question must be in the negative for two reasons. First, having regard to the obvious policy and object of the act. If section 79(1) is capable of two constructions, that construction should be preferred, which furthers the policy of this act and is more beneficial to the employees in whose interest the act has been passed. It is well settled that in construing the provisions of a welfare legislation, courts should adopt what is sometimes described as a beneficent rule of construction. So, My humble prayer, Lordship, before this honorable court, my humble submission is that, Lordship, this is a beneficial scheme, a beneficial legislation. The act is a beneficial legislation, the scheme is a beneficial scheme, intended to benefit the workers and casual employees employed by the state of Nagaland, Lordship. So it deserves to be constructed liberally, Lordship, so that the benefit actually reaches those employees to whom it was intended to be reached. Now, Lordship, in 1981, AIR SC 872, Lalapa Linkapa versus, this is a celebrated judgment, Elvid Textile Mills.
AIR
1981 SC 852.
Yes, pair number
13, my lord. The relevant paragraph appears at page 856. The judgment starts from 852.
Yes.
In construing a social welfare legislation, the court should adopt a beneficial rule of construction. If a section is capable of two constructions, that construction should be preferred which fulfills the policy of the act and is more beneficial to the persons in whose interest the act has been passed. Lordship, there are also, yes, there are also citations, Lordship, which says that
not
the,
necessarily
yes,
multiplied
which says that, Lordship, the executive instruction can only supplement the principal act, but
No,
it cannot.
that is well settled.
Yes, my lord,
That is
my
well
lord,
settled.
yes. Then in order to save this court's time, my lord, I may not place those rulings. Lordship, as regards the me not receiving the scale of pay, Lordship, I may be allowed to take my lords to page 32 of my writ petition first. The type copy is at page 33. This is my appointment order, my lord, clearly indicating my appointment
At page number
32. The type copy is at page 33.
of your reply.
No, my lord, the appeal memo, because in the appeal memo they have enclosed the writ petition
Page
along with
number
all the annexures.
30,
Yes.
32.
Yes, my lord.
32 is the appointment order.
Yes, my lord. And 33 is the type copy of the appointment order.
Yes.
So here, Lordship, the appointment order was issued on 31st of August 1984. I may be allowed to read this, Lordship.
Yes.
The operative portion. Office order. Designation rendered by Sri Angpa Kalasi, Angpi K, I'm sorry. Work charge as SS labor is hereby accepted with effect from 31st August 1984. Afternoon, Sri H. Angpe K of Langmai village is hereby appointed as labor in the scale of pay rupees 300 per month with effect from 1st September 1984 afternoon in place of Sri Angpa Kongyak. So, Lordship,
This is
from
scale of pay was granted to you.
it says so, Lordship, but in fact, I receive only fixed pay, despite the fact that scale of pay
Was granted to you.
yes, Lordship, but I receive only fixed pay, Lordship. And for 35 long years, Lordship, I never agitated it.
Yes, madam, what is this?
This could be a typing error. Otherwise, if a scale of pay is given as
No,
specific.
no, can you submit in that way that they say
No,
there
but
is typing error?
petitioner also never denied that he is on a fixed pay, Your Lordship. Petitioner never denied that he is on
No, that
fixed
is
pay.
a different aspect, but
Yes.
What does this office order says?
Yes, so the office order says a scale of pay
In the
of
scale
rupees
of pay.
300 per month, but your lordship knows the scale of pay starts from a certain range to a certain rate. So this clearly shows that it is a fixed pay, though maybe by typographical error they may have inserted scale of pay. But if at all it is to be a scale of pay, a certain a range of payment will be mentioned, your lordship. And petitioner also admitted that he is on fixed pay.
Yes.
Now, Lordship, I may continue. Now, the RTR reply, Lordship. I was the date is important. I was appointed in the year 1984. 31st August, I joined my service from 1st of September 1984, Lordship. Now, the RTR replied that the appellant has annexed at page 61.
Yes.
The information begins from page 62. So, my lord, here is a chart has been provided, designation, the date of birth, date of joining service, lordship. This is important. Has also been mentioned. Now, my lord, if my lords can kindly peruse. The date of joining service, they are all these 380 employees. They are junior to me, lordship. 1988, 87, 86. Some are. I don't see any 85 also.
Yes.
So, lordship, if
this list is of 300 employees.
Yes, 380 employees.
380.
Yes, lordship. All these are junior to me. And if the seniority list has been followed, lordship, for awarding scale of pay, I would have been awarded scale of pay long time ago, lordship. In fact, I have represented to the state government also. But that representation was not considered, lordship.
So where is your representation?
Lordship, Annexure 4 of my writ petition at page 36. Annexure 3 at page 35. Page 35 of the appeal memo, my lord. The entire writ petition is enclosed in the appeal memo, my lord. Page 35 is the first
35 and 36 both.
Yes, 35 and 36 both. Two different representations, lordship. One in 2015, another in 2019. Now again, lordship, the RTI that has been enclosed at page 76, the information starts from page 77. This is the list of the work charge employees who were regularized, lordship. All these work charge employees are also junior to me. Not a single one is above me. Here also the date of joining service is clearly indicated. Page 77, my lords. Now,
so they were regularized while the petitioner
was in service. Yes, lordship. Lordship, in fact, some of them were regularized the very day they were appointed, 8 of them.
Pardon?
The very day the work charge employee was appointed, 8 work charge employees were regularized that very day itself. I'm trying to project the case that there was discrimination, lordship. A pick and choose policy adopted by the state. Some of them were regularized without even reaching 10 years length of service. Lordship, I have given a chart at page 17 of my affidavit in opposition, filed in the writ appeal, lordship, at page 17. A table has been given. The list of 66 employees
Page number?
Page number 17 of my affidavit in opposition. Now I have made a chart for my lord's ready perusal. Here, Lordship,
Yes.
That-
Some of them were regularized
Yes.
only after 1 year.
yes, Lordship. Some of 66, out of those 66, 37 were regularized without completing 30 years of service. Some did not even complete 10 years, and then some were regularized the very day they were appointed.
So you have not challenged their regularization order.
No, my lord, because Lordship, I have filed RTR reply when I filed my writ petition before the single bench, Lordship. Now, in my writ petition, I have mentioned that I have given a statement that I have annexed those RTI applications also. The information is yet to be received. So as and when the information is received, I may be allowed to place those before the honorable
So
court.
whether the learned single judge has considered this reply?
Yes, Lordship. Yes, it is reflected in the
Judgment.
also, Lordship. It has been discussed, Lordship. Now, Lordship, since they are not also holding sanction posts, Lordship, because as per the Act and as per the scheme, Lordship, creation of sanction posts is not necessary, Lordship. And then I am not challenging I did not have any grievance, Lordship, against them. It's just that the benefit that has been extended to Mr. A, B, C, and D may also be the same. I am also similarly situated, or I am better situated. So that same benefit may also be given to me. I am not aggrieved by the regularization, my lord. Because, Lordship, as I've been at the cost of repetition, Lordship, the creation of existence of sanction posts is not a requirement for my regularization, because the post is converted to a regular post personal to me, Lordship. It is clearly reflected in the scheme.
Yes.
Now, my lord, my case before this honorable court is that, Lordship, Articles 14 and 16 has been violated, Lordship. I may be allowed to place EP Royapa versus State of Tamil Nadu, 1974 AIR SC 555.
But you have not challenged those regularization process, those
No, my
orders.
lord. No, my lord.
So
My
how
only
can
prayer
you
before this
plead this,
honorable
14, 15, and 16?
Lordship, my only prayer before this honorable court is that when a particular set of
So
employees,
is there any averment in your petition that there is a violation of Article 15, 16?
yes, Lordship, there
14,
is.
15, 16 in
Yes,
your
yes,
petition?
yes, as well as Article 21, Lordship.
Where you have mentioned it in your writ petition?
My writ petition is annexed at
Page number?
page
21?
number 21, my lord. It begins
Yes.
from page number 21.
In which paragraph you have made such averment?
Lordship, at paragraph 11, the state being a model employer ought not to discriminate its employees by adopting a pick and choose policy.
Acha.
And whereas similarly situated persons at the following paragraph have already been regularized and given pension and pensioner benefits. However, the same benefit has not been extended to the petitioner, and the same is in violation of Articles 14 and 16 of the Constitution of India. At paragraph 10, I have dwelled on the violation of Article 21, Lordship. Right to life. Now, Lordship, I may be allowed to place the 1974 AIR SC 555.
In respect of
Articles 14 and 16, Lordship.
AIR
1974,
page number.
page number 583, my lords, paragraph 85. Now, my lord, towards the end of page 583, Lordship, the last sentence, Lordship, Articles 14, instead of reading the entire paragraph in order to save this honorable court's time, my lord's time.
So is the name of the party is EP Royappa?
Yes, my lord, EP Royappa versus State of Tamil Nadu.
Pair number 85.
Yes, my lord. At page 583, is my
Yes.
lord. Yes, my lord. Towards the last portion of last sentence of the page 583, Articles 14 and 16 strike at arbitrariness in state action and ensure fairness and equality of treatment.
So the problem is that that book is not available in the library.
My lord, my lord.
We have been provided this SCC.
My lord, if I may be allowed to place.
Xerox copy?
Yes, my
Is
copy.
available? Okay, fine.
Copy, my lord.
Okay, no problem. As far as pair number is 6. Yes, so what about this 21?
Yes, my lord. That
Article 21.
yes, my lord. Lordship, I'll come to that later on. Article 21, Lordship.
So 14, 15, 16, all right. We
My
don't
lord.
require any more citation.
My lord, my lord. Now, Lordship, regarding the document that the Learned Government Council has relied on at page 55 of the appeal memo, I may be allowed to explain this document, my lord.
Page number?
55, which the Learned Additional Advocate General has read out. Page 55.
Yes.
Now, Lordship, this has been sufficiently replied by me at paragraph 13 of my affidavit in reply, affidavit in opposition, at paragraph 13, page 32 of my affidavit in opposition.
Yes.
Now, Lordship, this is only an office communication, Lordship, between two officers, Lordship, of the department. I don't have any privy to it, Lordship. And then they are discussing about some petitioners, Lordship, who approached this honorable court, Lordship, earlier. So the communication is confined to only those group of persons, Lordship. I may be allowed to read my paragraph, the relevant portion, Lordship. That the statements made in paragraph 7.5 after the appeal is denied being unreasonable, misconceived, and absurd. It can be seen that letter number so-and-so dated 23/7/2020, annexure 2 after you read appeal at page 55, that is the present document, my lord, is not a notification or office memorandum, nor a copy was served to the respondent petitioner, but is merely an office communication between two officers with regard to the petitioners in WBC 228/2018, in which case the answering deponent herein was not the party. However, it is pointed out that when the clear direction was given on 21/11/2018 by this honorable court, the department's action of limiting upgradation from fixed pay to scale of pay to only work charge employees who retired on or before 1/1/2020 is arbitrary and unreasonable classification. Such inaction only puts to clearer light the discriminatory acts committed by the appellants. I have also enclosed the order of this honorable court passed in WBC 228 K of 2018 at annexure 2 of my petition, lordship, at page 50. So at page 51, the operative direction given by this honorable court, lordship, is that at paragraph 5, considering the facts and circumstances submitted by the learned counsel for the petitioners and the submission of the learned government advocate, this writ petition is disposed of with a direction to the respondents, particularly the respondents number 4 and 5, to consider the prayer of the petitioners to pay them at the scale of pay within a period of 3 months from today. So, in presence of this order, my lord, this the office letter between the deputy secretary to the government of Nagaland and the chief engineer, sanitation and WSSO, it was written, lordship. I was not privy to this, lordship, and then it does not concern me, in short, lordship.
So,
So,
this communication was in persons to the order passed by this
yes,
court
yes,
in
yes,
241.
yes, those group of petitioners, lordship.
Not WBC number 228.
Yes, lordship, my lord.
So, how much time will you take?
My lord, maybe another 15-20 minutes.
15-20 minutes.
Yes, my
okay,
lord.
we'll come back after 5 minutes.
My lord, my lord.
Yes.
May I please, my lord.
Uh.
My lord, so if the contention, the submission of the my learned friend is accepted, then it will set a bad law, a bad precedent. Because tomorrow, lordship, somebody else will approach this honorable court, and then they will write a letter between two officers which does not concern me, and then they will say this, oh, this has not been challenged. Lordship, if this was an office memorandum, or this was a circulated document, which was published in some notice board or in the official gazette, then me not challenging it may affect me, lordship, adversely. But from this document, I have nothing to benefit, nor do I have anything against it, because it does not concern me at all, lordship. Now, my lord, coming back, lordship, to the issue of scale pay, lordship, the law laid down by the Honorable Supreme Court in Jagjit Singh versus State of Punjab, lordship. Now, this decision was passed when I was still in service, lordship.
Is Jagjit Singh?
Yes, lordship.
Yes. But have you pointed it out to the learned single judge?
Jagjit Singh, no, my lord. Because, lordship, there I was claiming for regularization, lordship. The issue of scale pay, lordship, because I was already retired by the time I was hurt, lordship. So the issue of granting scale pay did not arise at all, lordship. But what I just want to point out is that, lordship, Jagjit Singh has clearly laid down that be it work charge or contingency employee, scale of pay should be given, lordship. But that exercise has not been done, lordship. And if Jagjit Singh was followed, lordship, then I would have received scale of pay as well, lordship. Assuming.
So, before pronouncement of the judgment by the learned single judge, you have retired.
Yes, lordship, yes, exactly, my lord. Which is why I was only directed for regularization, lordship. Now, I may not read out Jagjit Singh, lordship is aware, lordship. Now, my lord, the judgment that they have annexed in the appeal memo, it is reported in 2022 for GLD SC page number 8. Now, lordship, this is a totally different case. Here, the petitioner, the appeal was allowed on 2 grounds, lordship, that he approached the court after a delay of 12 years, lordship.
In that case?
Yes, in that case. And that also, lordship, it was a case of posthumous regularization. The employee
person has already suffered demise.
Yes, while he was in service, lordship. And the wife approached the court praying for her husband's regularization after his expiry. So the single bench as well as the division bench has directed for his regularization 1 day ahead of his demise. Lordship, at paragraph 2, it is clearly stated that I may be allowed to read paragraph 2 from the GLD, Lordship. The deceased husband of the respondent was working as work charge Tokali. He died in harness on 28/8/2005 as work charge employee. Lordship, this is important. That in the year 2017 and after a period of 12 years from the death of the deceased employee, the respondent herein, widow wife of the deceased employee, filed a writ petition before the learned single judge. So, he was in the department for only about 12 years, Lordship.
That petitioner, the husband of the petitioner.
No, Lordship. Yeah, the court was approached after a delay of 12 years, Lordship. And Lordship, the husband during his lifetime
Mm.
never claimed for prayed for regularization, Lordship.
Mm.
So on those grounds, the appeal of the state was allowed.
Mm.
Now, Lordship, this judgment was passed by Justice A. Marsha.
Mm.
The same judge, Lordship, has passed the judgment relied on by the single judge, that is the state of Gujarat versus Talsipai. There, A. Marsha, the same judge, he has laid down that after serving the department for 30 years as a work charge employee in a welfare state, such as ours, Lordship, it would be unfair not to give him pension. That the operative portion has been reproduced by the single judge, Lordship, in his
Judgment.
My Lord.
Mm. And that judgment was pronounced by Mr. Emerson.
Emerson, my Lord, I mean, it's a short order. Lordship. It is unfortunate that the state continued to take the services of the respondent as an ad hoc for 30 years. And thereafter, now the content that as the services rendered by the respondent are ad hoc, he is not entitled to pensionary benefits. The state cannot be permitted to take the benefit of its own wrong, to take the services continuously for 30 years, and thereafter the content that an employee who has rendered 30 years continuous service shall not be eligible for pension is nothing but unreasonable. As a welfare state, the state as such ought not to have taken such a stand.
Mm.
In the present case, the High Court has not committed any error in directing the state to pay pensionary benefits to the respondent who has retired after entering more than 30 years of service.
But he was an ad hoc employee.
Yes, Lordship. Yes, Lordship.
So
Now-
your case is more bitterly situated than the petitioner of this petition of this case.
Yes, I am in a better
So
situation.
here he was an ad hoc employee.
Yes, my lord.
And you were an
Workforce
HDM.
employee, yes. And there is a scheme for my regularization, Lordship, which speaks about converting my post into a regular post personal to me, my lord, personal to the employee. It does not envisage, it does not envision, Lordship, regularizing a work charge employees against a sanctioned post, Lordship.
Mm.
Now, Lordship, the judgment relied by my learned friend reported in 2021 SCC Online SC 899. Union of India versus Ilmo Devi.
Mm.
Here, Lordship, the scheme, Lordship, discussed in that particular judgment, it speaks about regularization against sanctioned post. Not unlike in our case. In our case, Lordship, sanctioned post is not necessary, Lordship. Because the scheme, it clearly provides that, Lordship, my post shall be converted to, because sanctioned post, Lordship knows, Lordship. It is yes, I need not explain it. And in that case, Lordship, they were not work charge employees. They were only part-time employees, Lordship.
Mm.
And it has been stated at paragraph 26 of that judgment that regularization is a policy decision of the state.
Mm.
So therefore, my case before this honorable court is that I am squarely covered by the policy decision of the state. It's just that, Lordship, that policy has been employed in a pick and choose manner, Lordship. And in that process, I was denied, Lordship. Otherwise, I am squarely covered. I ought to have been granted scale of pay when I was in service, and I ought to have been regularized immediately, Lordship, on completion of 30 years. Now, Lordship, the judgment, the last judgment that my learned friend relied upon.
The division bench judgment.
Yes, yes, Lordship. Lordship. There, Lordship, that judgment is, if I may say so, Lordship, a pet precedent, Lordship. It is not
Why?
Yes, why? Because I will tell you, my Lord. It is pure incurium, it cannot be relied upon. Firstly, Lordship, there is a decision, another decision passed by the division bench on the same issue. Earlier decision, my Lord. Now the law is well settled that when two coordinate bench passes similar decision on similar grounds, the
The
decision.
first one will prevail. That is the doctrine of precedent.
Yes, my Lord. My Lord. So, my Lord, I may be allowed to place the.
That judgment. Yes. But in such situation,
yes,
we have to place the matter before the Chief Justice to constitute a larger bench.
My Lord, my Lord.
That is the procedure.
My Lord. My Lord. Those aspects, my Lord, I leave it to my Lords, Lordship. If I may be allowed to place
Yes.
a citation on this, Lordship. The latest is 2017-6.
That Prannoy Sethi.
Yes, yes, Lordship. Yes.
Yes.
Yes. I need. Prior to that, also in S.K. Kapoor's case, Lordship, similar view has been taken. I need not place those, Lordship. Lordship is aware of those decisions. Now, Lordship, in the judgment placed the latest division bench decision, I am not similarly situated with that petitioner, Lordship, because there the petitioner served for 26 years. Here I have served for 35 years.
Yes.
Now, I believe, yes, at paragraph 11 of the judgment that was placed.
This division bench?
Yes, the latest division bench decision passed in WA 27 of 2022. The length of service is clearly reflected, Lordship.
Para number?
11. Page number 13, my lord, paragraph 11. State of Nagaland versus Alamba.
Yes.
Here, the ratio laid down in the case of so and so and so and so, in our opinion, squarely covers the present case. It is no doubt correct that the respondent has rendered more than 26 years of service as work charge employee. So, since under the scheme, Lordship, it speaks about 30 years length of service, Lordship. So, his 26
Yeah,
years,
26 years.
yes, was also one of the grounds for which the writ petition was allowed. The writ appeal was allowed, Lordship. Now, my lord, in the three judges bench of the Honorable Supreme Court, in Prem Singh versus State of UP, 2019-10 SCC 516. It was the three judges' bench clearly laid out that an employee who has discharged the duties with the department for 3 to 4 decades is deemed to be a regular employee, so as to make the said employee eligible for grant of pensioner benefits.
In which matter? Which citation you?
2019-10 SCC 516, my lord. At paragraph 36, Prem Singh versus State of UP. Here also, Lordship, I have served for more than 3 decades, 35 years. 35 years, Lordship, is a long time.
This is a 3-judge bench decision.
Yes, my lord. I may be allowed to rely on paragraph 36.
Paragraph 36.
Yes, my lord. I may be allowed to read this, my lord. This is my last citation, Lordship.
Yes.
There are some of the employees who have not been regularized in spite of having rendered the services for 30 to 40 or more years, whereas they have been superannuated. They also have been superannuated. As they have worked in the work charge establishment, not against any particular project, their services ought to have been regularized under the government instructions and even as per the decision of this court in Secretary State of Karnataka versus Umadevi, 2006 for SCC 1. This court, in the said decision, has laid down that in case services have been rendered for more than 10 years without the cover of the court's order as one-time measure, the services be regularized of such employees. In the facts of the case, those employees who have worked for 10 years or more should have been regularized. It would not be proper to regulate them for consideration of regularization as others have been regularized. We direct that their services be treated as a regular one. However, it is made clear that they shall not be entitled to claiming any dues of difference in wages had they been continued in service regularly before attaining the age of superannuation. They shall be entitled to receive the pension as if they have retired from the regular establishment, and the services rendered by them right from the day they entered the work charge establishment shall be counted as qualifying service for purpose of pension. Now, my lord, my humble submission before this honorable court is the learned single judge. He did not commit any error, Lordship, in allowing the writ petition. In fact, there are also other division bench decisions where similar
reliefs were granted.
Yes, my lord. In one,
not necessary to
yes,
multiply
but I
this.
may be allowed to give the citation. I won't read it out, my lord.
Not necessary.
My lord. Then in that case, my lord,
Yes, madam, any
conclude.
reply?
All along he has been saying that he is covered under the 2015 scheme, saying that he had served for more than 30 years. But he does not come under the scheme of 2015 because he is not enjoying scale of pay. Yes, so he will come under the scheme of 2004. So where the scheme of 2004 clearly says that regularization will be as per the seniority and as per the availability of the vacancy. So the petition, I have shown you earlier also, petitioner number, the petitioner stands at serial number 9 at the time of his retirement. So he does not come between the policy of the government for regularization of the service. Petitioner also rely upon the Premsin and Patalsibai Danjibai Patel. All this has been answered by the division bench of this honorable court in WA 27 of 2022, State of Nagaland versus Alemba, that is at para 17, saying that the division bench of this court says that all this decision has been rendered in the facts and circumstances of that particular case only. So your lordship, the Supreme Court principle that was laid down by the Supreme Court in a state of Nagaland versus Shivi says that during the lifetime of the petitioner, he does not come within the policy of the for regularization. So even in our case, also your lordship, during his service time, he does not come within the regularization policy of the state government. So the direction given by the learned single judge directing the state to regularize is adverse to lordship. So that needs to be interfered with. That's my opinion.
Okay. Heard Ms. Sukari, learned additional advocate general for the appellant, and Mr. Saint-Pierre, learned counsel for the respondent. Argument concluded, judgment reserved.
Deeply obliged, my lord.
Mr. Iyer, by this, you give me the list of citations.
My lord, my lord, my lord. I will.
And the Xerox copy also,
My lord,
because we cannot carry the books with us,
my lord, my lord.
because we have reserved the judgment. No?
Lordship, if I can kindly give it tomorrow, my lord.
Yes, no problem.
My lord.
Yes. That's great. Mr. Iyer, he will manage it from the library.
My lord, my lord. Thank you so much.
This side. No? Okay. This side. This side.
Right.
110